I think it's so bad, they've actually done us a favor because now it just so flies in the face on the common use test. Modern guns are protected. All the things that have been reiterated through Heller, Bruin, and so on. I think this thing is just so bad that they're going to take it. And I think it's time that after over 15 years that this issue gets hammered out. So I think we've literally got 9 more months.
It's gun rights advocate Todd Vandermyde in a conversation I had with him yesterday, reacting to the case out of Maryland and the gun ban there being upheld by an appeals court on final judgment, and the trajectory of it going to the Supreme Court of the United States. Welcome in. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Join us each and every weekday morning as we break down stories that are impacting you here in the land of Lincoln. Find the podcast anywhere. Just search Illinois in Focus, and you can get the newsletter with the Center Square. Go to thecentersquare.com. So we talked yesterday about the ruling earlier this week out of Maryland in a federal appeals court upholding the Maryland gun ban and what that means. This is the Bianchi case. And for those who've been tracking these cases across the country, not just here in Illinois, we've seen that there are different cases at different stages. Well, the Bianchi case was in front of an appeals court on final judgment. This had already gone back to the district courts after the Bruin decision, the New York State Rifle and Pistol Association v. Bruin out of New York, where the U.S. Supreme Court made it clear that in order for gun laws to be constitutional, they need to match up with text, history, and tradition, going back to founding era understanding of the Second Amendment and why it's necessary as a right, fundamental right, the second right on the Bill of Rights, right after free speech, freedom of assembly, free religion, and so on, freedom of the press, for example. So you've got this ongoing question of, well, what kinds of weapons or firearms can government ban? Illinois has a gun ban and a magazine ban in place. It's been in place since January of 2023. Here we are now in the second week of August of 2024, and lawsuits have been filed, and they've gone all the way up to the U.S. Supreme Court, but they were only on preliminary grounds in the state of Illinois' challenges. Maryland's case, much further along. What does all this mean for the Second Amendment? Todd Vandermyde here, again, a gun rights advocate in the state of Illinois. He's also been a consultant on some of the cases in the Southern District of Illinois that are challenging Illinois' gun and magazine ban. So he has a keen understanding of the variety of factors involved and all the arguments that are being made. In particular, what the Maryland case being queued up for the Supreme Court ultimately means for the Second Amendment.
Well, a couple of things. This judge must have read the Seventh Circuit opinion in our cases and jumped off his meds and put it on steroids. There are a whole host of things that are wrong with this case. I have a bunch of cliff notes. They have doubled down on the concept that in order for a firearm to be protected, it must be used in self-defense. That's not the standard. And they're saying possession for self-defense is not enough. It has to actually be used in some way. They sit there and talk about criminal misuse of firearms, and that they get to the point that, so much so that if criminals use something too much based on their standard, it can be banned according to that. They jumped the shark in this thing in a way. So if you remember during the arguments, Justice Easterbrook brought up the concept of man-portable nuclear devices that were tested out in the Vietnam vintage. Well, here, Judge Wilkerson, in his opinion, goes beyond that and talks about umbrella guns that would fire ricin pellets and brings that whole notion in here. It's crazy. They talk about, they go how 50 caliber firearms are so dangerous because of their ballistics, and then they import all the ballistics of a 5.56 or 2.23 caliber rifle into this and try to equate that for dangerousness using ballistics, yet they don't ever talk about pistol caliber carbines, obviously ARs that shoot 9mm or their equivalents, It is just they throw a whole bunch of interest balancing in there, even though they try to hide it. They talk about all the mass shootings that have happened. They just wear that. This is like a gun control screed for the best of it. They talk about how technologically there's a small thing in Heller about, such technological advancements may force us to look at things a little differently. And they basically say that semi autos were not around at the beginning, therefore, you can use this exception and try to walk in a bunch of other stuff. They go back to the traditional Bowie knife argument that Bowie knives were regulated at the time of the founding as some sort of ultra dangerous knife or whatever. And because of that, they sit there and say that therefore that leads to the regulation under the Rahimi principle of a general doctrine. And then they cite all kinds of laws from 1839 to 1923. They are leaning real hard on using 1865 as the time to be looking at for the appropriate laws. And then they draw a direct line from the Bowie knife bans of the time of the founding to the National Firearms Act of 1934. And they use that to justify what they did. They basically, these are not arms; they're military features. Take them out of that category. They lean real hard on the M16 analogy that the Seventh Circuit used and put it on steroids. And it's 65 pages long of just an anti-gun um, manifesto of why. And I think it's so bad they've actually done us a favor because now it just so flies in the face on the common use test. Modern guns are protected. All the things that have been reiterated through Heller, Bruin, and so on. I think this thing is just so bad that they're going to take it. And this now tees us up. They said that there was no reason for a remand. They said that, it's like, hey, just time for us to get on with this. And I think that this will be, I think a cert petition will be filed shortly, and it'll be up. Now, I think the thing to watch is, does the other side, the state of Maryland, try to, oh, we need more time to brief it and try to drag their feet to slow this down? It's already been to the Supreme Court before. Bianchi was GVR'd post uh, Bruin over 2 years ago, so it was already briefed prior. So the court shouldn't give them a lot of leeway on that. I will expect them to pull that delay. I will expect them to pull down and say there's no split in the circuits and try to play that card, as a way to try to keep this from reaching the court. But it's so bad, I think it's going to help us.
So again, that's Todd Vandermyde sharing some of his initial thoughts here on the Maryland case and all the particulars about the Maryland case, essentially upholding the ban on semi-automatic firearms. But if you look at, Maryland's case heading to the Supreme Court, Illinois' cases went to the Supreme Court, didn't they? Well, they were denied to take up a certiorari petition because it wasn't a ripe case. And what does that mean? Well, listen, if you've been following all of this, hopefully you understand the difference between a final judgment and preliminary action. Preliminary action is just an initial request of plaintiffs to take a certain action while the rest of the case is dealt with. So we had in the Southern District, for instance, this is April of last year, if you recall, the 6 days that the state's law was enjoined in Illinois from being enforced. So people went out and bought a whole bunch of semi-automatic firearms and magazines over certain capacities for 6 days before an appeals court reversed that preliminary injunction. All of that was the first kind of steps. It wasn't on final judgment. So those preliminary actions went up to the appeals court and they ultimately sided with the states. And then plaintiffs in these cases went to the Supreme Court and said, hey, on a preliminary basis, take this case. Well, last month, if you recall, you had Justice Clarence Thomas deny taking those cases, essentially saying that these are all on preliminary actions, and the Supreme Court's looking forward to having a detailed record to actually make a ruling on this case once and for all, on this idea, not just Illinois' case, but the idea altogether of a ban on certain types of firearms. And can the government go that far? And I think this is going to be important, especially heading into the November election. Will we have a determination before then? I don't think so. But Kamala Harris and her vice presidential candidate, they have essentially said that there needs to be a ban on, quote, semi-automatic firearm or assault weapons, they call them. So background of, Illinois' case going up to the Supreme Court denying that, it was because it was on preliminary grounds. Vandermyde yesterday, when I talked with him, he said that the Maryland case is on final judgment. And that may be exactly what Clarence Thomas was looking for.
Well, look at what Clarence Thomas said. He said they wanted a case that was done on the merits with a record. Here, they've got a record. And now they've got an egregious finding by not just a court of appeals, but an en banc court of appeals. That is all the judges. So there is no three-judge panel that you then appeal en banc to see if you get they're playing the games in the fourth that they've been playing in the Ninth Circuit on issues. So yeah, the next stop is the Supreme Court of the United States. And with Illinois, we've got a trial. Now, if you'll remember, Judge McGlynn issued a order, and he had a kind of a checklist of things that he wanted to hear about. Great. I think you line that checklist up with what this judge wrote in this opinion. And we know the state is going to glom onto all these arguments. They've been making some of them. They are going to glom onto all these arguments. And this just gives us, it's like an open book test. We've been given the answers ahead of time to deal with them. And I expect our attorneys will deal with all of these just like this.
And tons of other cases across the country. You've got, this week, a district level New Jersey court saying that their gun ban was unconstitutional, but the magazine ban was constitutional. That's at the district court. You've got a case that's held up over in California. I believe that's in the appeals court, but I don't even think they've had a hearing yet. You've got all these other cases across the country. The Maryland case being the first that's going to actually go to the U.S. Supreme Court on all of this.
This case is only a gun ban. It's not magazines. If you'll remember when we did the Illinois stuff, 3 of the cases down there are guns and mags. Our case that I'm involved in with FFL is guns and parts, repairs. Okay? And I haven't studied the Maryland law in that depth to talk about, how the two relate. Obviously, I don't think Maryland's list is 170 guns long, but they do have the generic features test that is different than ours, but close. Theirs is a dual feature test, not a single feature test. So when you look at all that, and don't forget, and they dropped another case yesterday about felons in possession and serial numbers that didn't go our way, but there's a whole nother line about that. But don't forget, this en banc panel also has the Moore decision in the Maryland FOID card case.
So there's a lot of other cases out there impacting Second Amendment rights, including cases in Illinois challenging Illinois' FOID card case in federal court. Not much movement there. But when it comes to the gun bans, Illinois, we have a bench trial set for September 16th in the Southern District of Illinois Federal Court. Could the judge there issue a final judgment and say the law is unconstitutional and ultimately put another injunction on the law while it goes to the appeals courts, and they may reverse that injunction while they take the case under consideration, and then who knows how long that takes before it gets to the U.S. Supreme Court. While we're waiting for that to play out here in the state of Illinois, Maryland's case is up first. Again, final comments from Todd Vandermyde.
They are Seabiscuit. They are out in front, and they're there. And it's a final judgment. It's all on the merits. It's all on the findings, which is what we wanted. So now, I think that what's interesting is there's a clip from Justice Gorsuch at his confirmation talking about the Second Amendment and Judge Wilkerson, who had authored the prior opinion on this issue out of the Fourth. And so I think that it kind of, leads you kind of where Gorsuch is. You got Alito, you got Gorsuch, you got Thomas. You got Kavanaugh, who sat there and wrote a dissent in Heller 2 on semi-autos. That's 4. I think you're going to pull Barrett and the chief along with it. I think it's time that after over 15 years that this issue gets hammered out. So I think we've literally got 9 more months.
Again, thanks to Todd Vandermyde for talking with me yesterday. Clearly an issue a lot of people are interested in, and we will continue to cover that as it unfolds. It is Illinois in Focus Daily. I'm Greg Bishop. Thank you so much for being part of the program each and every weekday morning.